This is a prototype of a much longer presentation I'll be making regarding the problems in global business ethics. I'll begin with an overview of the main problems faced by multinational corporations, and then I'll go into detail about the specifics of the Foreign Corrupt Practices Act. Then I'll go through some examples, both actual and theoretical, followed by theoretical analysis and decision procedure provided by the Kantian perspective and other contemporary perspectives in business ethics. And I'll conclude with a section on the duties of multinational corporations as perceived by some of the best experts in global business ethics. This is a reproduction of the Corruption Perception Index map produced by Transparency International. Countries are rated on a scale of 0 to 10, 10 being no corruption and 0 being very corrupt. The darker colors represent more corruption. As you can see, most of the world's population lives in countries that are rated quite low on the scale, the darker colors on the map. And there's only a few countries that have ratings of 8 and above, indicating very little corruption. So corruption and bribery, as we shall see, is a worldwide problem. And the question is, what is the role of multinational corporations in addressing these problems? The UN Global Compact is a useful guide to the responsibilities of contemporary international businesses. It's hard to object to these goals, but clearly there are red flags for any international business regarding items 6 and 10. Is it really the responsibility of businesses to try to fix a social problem like discrimination in another country? And what about corruption? Isn't that the problem for local governments? We can put the problem another way. Should corporations act as the agents of government? Yes, corporations can collect sales taxes on behalf of the government, but what about addressing social issues? This question becomes crucial if one is trying to follow the laws of one's own country while doing business in another country. Clarity in global business ethics depends on understanding this relationship between business and government. Slide 6. We can even look at the problems faced by MNCs from an abstract systems viewpoint. Markets that do not have shared moral rules are inefficient. For example, if bribery is practiced, the true cost of goods and services is not known, and productive capacity is wasted. A globally shared morality of the market eliminates forms of corruption such as bribery, and that should increase productive capacity. A shared morality of the market can be created by inputs from international agreements, cultural and moral systems, national governments, and multinational corporations. So ultimately, it appears that MNCs can help increase the wealth in the world by helping to create a shared morality of the market. The question remains, however, is how multinational corporations are going to do this. What procedures should they follow? Which kind of moral norms should they enable in this process? Slide 7. To summarize the problems faced by MNCs, when doing business in foreign or host countries, which moral standards should be applied? The host country standards, home country standards, or universal standards? For social programs, what is the appropriate relationship between government and corporations? And do MNCs have duties not only to comply to standards, but to help to create new ones, to create a shared morality of the market? So we'll keep these questions in mind as we proceed to discuss various provisions of the laws. The Foreign Corrupt Practices Act of 1977 states that it is unlawful for U.S. citizens or U.S. corporations to make payments to foreign government officials to assist in obtaining or retaining business. For example, if you pay a foreign government official in order to influence the foreign official in his or her official capacity, induce the foreign official to do or omit to do an act in violation of his or her lawful duty, or to secure any improper advantage, you have broken U.S. law. even if it is not against the law in the country in which you are doing business, you will still pay the penalty if your act is discovered by U.S. officials. Currently, the FCPA rules have expanded to an international basis. In 1997, the OECD member nations were also required to make laws very similar to the U.S. law and to make bribery of foreign officials a crime. In 1998, the U.S. expanded its own law to cover foreign firms and foreign persons inside the United States who make corrupt payments. So the potential impact of this expansion of the FCPA is enormous. It's really a first step in criminalizing corporate bribery of government officials worldwide. I think we're already beginning to see a shared morality of the market as it's developing. Slide 10. There are, however, some very substantial and trouble-causing exceptions to the basic FCPA law. Many countries have a long-established unofficial cultural practice of requiring unofficial payments or gratuities to low-level government officials. Some people regard these payments as the equivalent of tips. Failure to make these payments often results in inability to do business in third and second world countries. Because of these facts, the FCPA does not call for fines to corporations if such so-called facilitating payments are necessary to induce officials to perform their duties. For example, if it is necessary and customary to pay a small gratuity to a minor public official in order to get utilities provided at your new office in a foreign country, this is not considered a crime. On the other hand, if you go way out of your way to bribe government officials in a foreign country in order to get special treatment and an unfair advantage over others, that is a major crime. That's what happened in the case of Walmex, the American subsidiary of Walmart. Walmex paid over $24 million to hundreds of city council members and mayors in order to obtain favorable construction permits and reductions in environmental impact fees. The crimes were committed by employees of Walmex, but the parent company, Walmart, is still responsible and faces fines of over $5 billion. Slide 12. Now that we understand the basics of the law, let's turn to what we will call a theoretical example, although it is drawn from real-life business practices. In other words, we expect that many international companies face this kind of situation constantly. This example was provided by Donaldson and Dunphy. Here's our scenario. On competing for a bid in a foreign country, you are introduced to a consultant who offers to help you in your client contacts. A brief conversation makes it clear that this person is well connected in local government and business circles and knows your customer extremely well. The consultant will help you prepare and submit your bid and negotiate with the customer for a substantial fee. Your peers tell you that such arrangements are normal in this country, and that a large part of the consulting fee will go directly to staff people working for your customer. Those who have rejected such help in the past have seen contracts go to their less fussy competitors. Slide 13. A Kantian analysis of the consultant fee example is straightforward. First, the consulting fee is used to induce employees of the foreign firm not to perform their duties to work in the best interests of their firm. The fee subverts the principal-agent relationship. As we know, Kant would not approve of any act that induces people not to perform their duties. Second, the idea that it would be permissible to pay the fee does not pass the categorical imperative test. One cannot will that this should be a universal practice because it would make honest, efficient business and the true principal-agent relationships necessary for business impossible. As a matter of fact, this is precisely what happens in countries where bribery is common. It makes their markets inefficient. Therefore, even though legal, since the consultant is not a government official, the payment is morally wrong. Slide 14. The theoretical analysis provided by Donaldson and Dunphy in their 1999 book integrated social contract theory, ties that bind, is quite different. They make a number of initial points. First, the consulting fee case is typical of doing business in foreign countries. It is best to face reality before making judgments. Second, consulting fees are not obviously wrong. They are not illegal, and they may not be immoral in the context of international business. Third, the idea that the consulting fee case may not be wrong has support if we compare the case to one that is more obviously wrong, a case that clearly does violate some fundamental norms. For example, although the law required washrooms to be racially segregated under apartheid in South Africa, companies were morally right not to follow the law. Slide 15. Donaldson and Dunphy also provide some guidelines about corporate attitudes that may drive moral decisions in business. They suggest there are four main types of corporate attitudes. The first is the foreign country type. This type of company adopts standards of the host country. If bribing is the standard, they pay the bribe. The second is the empire type. This type of company tries to apply domestic standards without modifications. If bribery is not common in their own country, they will not pay bribes in other countries. The third is the global type. This type of company assumes global uniformity is the only answer. Until laws against bribery are universally enforced, this type of company would probably not pay the bribe. Finally, there is the interconnection type. This type of company insists on meeting universal moral minimums, but also acknowledges national or regional values that may be on the margins, but are still acceptable. Donaldson and Dunphy favor this last type because, as we shall see, it fits with their theory. Slide 16. To state Donaldson and Dunphy's view briefly, they reject views inspired by what they think are ideological extremes, namely relativism, or the foreign country type, imperialism, the empire country type, and idealism, the global country type. They accept what they call hypernorms, that is, basic human rights and values, universally accepted. Standing up for human rights to free speech is an example. But they also incorporate a relativistic component in their theory. They accept, or at least are willing to work with, any norms that fall into what they call moral free space. They define moral free space as a system of cultural and/or national values and practices or beliefs that do not severely violate universal norms, but may be in tension with them. Slide 17. With the basics of Donaldson and Dunphy's theory in mind, let's see how they come to a final conclusion. The main question they pose is bribery in the moral free space? That is, although we might object to it, is it nonetheless permissible in some cases when involved in international business? Donaldson and Dunphy make the following observations. All religions oppose bribery. All nations have laws against it, although these laws are often unenforced. Even in countries that seem to run on bribery, such as India, many people oppose it. For example, executives in India oppose it, although they feel forced to participate because they cannot do business without participating in the practice. It would seem to follow that bribery is not in the moral free space. It violates too many universal norms. It would follow that in the consulting fee example, the fee should not be paid. Although Donaldson and Dunphy do not state this explicitly, this seems to be their implication. Their final conclusion, however, is at odds with this implication. They point out that refusing to bribe is refusing to do business. And even worse companies may become involved if your company does not participate in business in that country. So finally, they state, at the level most managers confront it, bribery has no satisfactory solution. Slide 18. Although their conclusion may seem unsatisfactory for individuals trying to make decisions in the real world, Donaldson and Dunphy point the way toward an ultimate solution. They state The answer then lies not at the level where individuals face bribery, but the level of the host country's background institutions. A solution involves a broadly based combination of business pressure, legal enforcement, and political will. In other words, they point toward the necessity of creating a shared morality of the market. And they open up a host of questions that we indicated at the beginning. What are the responsibilities of MNCs and governments? What is the right role for multinationals in trying to create social change? Slide 19. Let's return to some of our initial questions. Which moral standard should prevail in international business? In general, there is some agreement on the answer to this question. Some mixture of universal and local standards, where local standards do not violate fundamental norms. But we also saw that in the real world, it is not always easy to take a firm moral stand, so problems like bribery and various forms of social injustice resist simple solutions. For social programs, what is the appropriate relationship between government and corporations? Well, for Bowie at least, the answer is relatively clear. Corporations should act as agents of the government in social reform programs. That's a topic that I'll have to expand on in another presentation. Finally, to what extent should MNCs go beyond mere compliance with local and/or international standards and be involved in creating new standards? Again, there is some agreement that MNCs should work with governments to create moral background conditions, in other words, a morality of the market. Slide 20. Philosopher Richard DeGeorge published a list of duties of multinationals that fits very well into our presentation. The main duties I want to emphasize are the first two. Do no harm, and try to produce more good than harm in host countries. It sounds simplistic, but it is a great reminder that we should think of the total impacts made by multinationals. Items 6 and 7 are also worth mentioning. Item 6 reiterates the advice of Donaldson and Dunphy. Allow for local norms that do not violate fundamental moral norms. And item 7 indicates that MNCs have duties to help build just background conditions. These conditions include what we have called the principles of forming the morality of the market. Slide 21. We began with a general question. What are the responsibilities of MNCs when doing business in other countries? We used the Foreign Corrupt Practices Act as an example of the moral dilemmas that corporations often face when doing international business. We said that creating a general morality of the market in which certain values, such as anti-bribery, are in effect, is one of the best ways that national governments and MNCs can work together. At the same time, we said that in some cases, host country standards needed to be given their due as long as they did not violate other more universally accepted standards. Although in some cases, businesses face a hard choice, either conform to unpleasant local customs or do no business at all. The result is a difficult position for MNCs. They are pulled in many directions and will often be forced to adopt compromise positions that occupy the broad middle ground of acceptable international business morality, hopefully aimed at doing more good than harm in host countries. Well, that's it for our presentation. I hope you enjoyed it.